Can you hear me?
Good day, Prof.
Good day.
Good morning, Prof.
It's day, not morning. No.
Well, it's morning for me. It's 6 a.m.
Oh, okay. Early morning in the US.
Yes, it's 6 a.m.
Okay. Around 5 a.m., I guess?
6 a.m.
6 a.m. Okay.
Yeah.
All right. Jawda, are you set? Okay. Good day, all. Today's presentation is by. Can you hear me all?
Yeah. I can hear you, Peter. Why you can't hear?
Professor Peter, can you hear us?
Let him.
Professor Peter, say a word so that we. Can you hear us?
It seems he cannot.
Yeah. Jawda, can you help Professor Peter Akpe? He can't hear us. Professor Peter, can you say a word? Jawda, can you rescue our chairman? Yes. Professor Peter, you are not audible. Can you say a word? Or can you hear us?
Unmute your mic. Okay. Unmute your mic.
Professor Peter.
Let him unmute his mic.
Can you hear me, sir? Can you hear me, sir?
Yes.
Yes.
Can you hear me?
He's got 2 devices on.
Okay. All right. Let's start with some introduction while Jawda tries to get him on so that we can hear him. All right. Kindly allow me to welcome you all to this report presentation on we put up a committee to help us track developments in this area and in this context, and a powerful team for that matter at the Institute did their best to raise some fundamental issues, problems and challenges, and then prospects in the context of COVID-19 national response measures. So today we would like to share their interim report with the entire public, with a view to taking some inputs and also accommodate some new developments that might have not been accommodated at the time the report was ready, so that after today's presentation, we hope to fine-tune actually the report, update it, and then get a final report ready for presentation to the following: the Honorable Attorney General of the Federation and Minister of Justice, Justice of Nigeria, the President of the Nigerian Bar Association, and then we show up the public and other relevant stakeholders. This actually is our ultimate objective or goal, with regards to today's session. So the report will be on our website, and it will also be circulated widely to the relevant stakeholders. So I would like actually to, if the committee chairman, Professor Peter Akpe, SAN, is ready and is audible enough to join us, and he will actually introduce or allow his committee members to introduce themselves for a minute each, and then he will lead in the presentation for 10, 12 minutes. Then other members of the committee will chip in for 3 to 5 minutes before we actually open it for questions and answers and comments from other stakeholders that have joined us from MDAs, from within and outside Nigeria. So welcome your input. So please feel free to help us track any new development that we have not been able to capture in our report, which is interim. Professor Peter Akpe, if you are ready, otherwise we'll start by asking members of the committee present to introduce themselves. Okay. Oh, you are ready. Okay. Okay. So I've just introduced the reports and why we are having this session. So Professor Peter Akpe, as of the committee, the floor is yours. Allow your members to introduce themselves in 1 minute each, and then you will take 10 minutes or 12 minutes to give us the gist of the report, and then members of the committee, about 6 or 7 of them, can now chip in on specifics before we open the floor. So the floor is yours, Professor Peter Akpe.
Thank you, DG, esteemed colleagues, ladies and gentlemen, and participants at this webinar. My name is Peter Akpe. I'm the chairman of the NILES Committee on the Impact of COVID-19 on the Justice Sector. My co-chair is Professor Adebambo Adewokwo, Senior Advocate of Nigeria, Professor Paul Idonije, Senior Advocate of Nigeria, Chartered Arbitrator, Professor Animi Silvanus Pepul, Professor Emily Alemika, Dr. Ibe Ifekandu, Dr. Azad Habila, and Dr. Osato Erogwa, who serves as our secretary. Now, our committee was given a mandate to assess the impact of COVID-19 on the entire justice sector and on the administration of justice in Nigeria, also to document innovative interventions relevant to the sector from within and outside Nigeria in the context of COVID-19, to also articulate practical and policy-oriented recommendations to the Honorable Attorney General of the Federation and Minister of Justice, the Honorable the Chief Justice of Nigeria, and the President of the Nigerian Bar Association on how best to implement the National Justice Policy adopted in 2011, and then make other relevant recommendations. The way we have structured the presentation of our report is like this. The secretary of the committee will take us through the mandate and the structure of the report generally. I will come in and weigh in on the summary of our recommendations, observations and recommendations. Professor Paul Idonije, Senior Advocate of Nigeria, we deal specifically on terms of reference 1 and 2. Sorry, Professor Adewokwo, SAN, we deal specifically on terms of reference 1 and 2. And Professor Paul Idonije, Senior Advocate of Nigeria, Chartered Arbitrator, we deal with terms of reference 3 and 4. So with the kind permission of the DG, I would like to yield the microphone to our secretary, Osato Erogwa, to present the structure of the report before we commence the discussion. Thank you, sir.
All right. The floor is yours. I would like to recognize and appreciate the following distinguished person that joined us from outside the Institute. Professor Dr. Bello Fadile from Houston, Texas, US. We have also Professor Abiola Sani from University of Lagos, Faculty of Law. We have Professor Timothy F. Yerima from Kogi State University. we'll continue to announce. Then we have Professor Kasim Balarabe, who joined us from India. So we'll continue to announce, people that join us actually as they join us. So you have the floor, Dr. Osato.
Good afternoon, Digital. Permit me to start on existing protocols. I will go directly straight to the purpose of the committee and then the TORs and the structure of the report. So basically, based on because of the spread of the coronavirus in Nigeria, the government at national and subnational level applied proactive measures that affected various sectors, including the justice sector. Now, to enhance navigation of necessary adjustments for the purpose of access to justice and justice delivery amidst the pandemic, the justice sector continued to receive a plethora of reform-related or reform-oriented measures that have affected the way the sector has been able to provide access to justice and justice delivery. In line with its mandate, the Director General of the Institute, as stated earlier, did it necessary to undertake a thorough, through a committee, a holistic and in-depth review and evaluation of the justice sector-related measures in relation to the pandemic. For the Justice Sector Act, the 8-man committee was inaugurated on the 4th of April to complete its work in 4 weeks. So complete it and submit its report within 4 weeks from its inauguration. The committee had 4 terms of reference. First of all, to assess the impact of COVID-19 on the justice sector and on the administration of justice in Nigeria. TOR was to document innovative interventions relevant to the sector from both within and outside Nigeria in the context of COVID-19. TOR was to articulate practical and policy-oriented recommendations to the Honorable Attorney General of the Federation and Minister of Justice, the Honorable Chief Justice of Nigeria and President of the Nigerian Bar Association, and other relevant justice stakeholders on how best to implement the national justice policy adopted in 2019. And the last term of reference was to make any other recommendation to appropriate authorities in the justice sector. And carrying out this assignment, the committee adopted the following strategy. First, it called for submission of an received memoranda from non-academic and academic members of the Institute on the various TORs. The committee conducted a preliminary review of the various TORs. The committee gathered and studied documents relevant to the assignment using a timeline analysis approach. This approach involved collecting and analyzing event-related data to determine when and what justice sector related measures existed. Cut-off date for basically the report, the findings, the observation and recommendations of the committee is presented in a main report and an appendix. The 6-chapter main report consists of an executive summary, a background chapter, and a chapter each for 4 terms of reference. So 6 academic and non-academic members of the Institute, as well as the justice sector reform that were considered in the main report. Thank you.
All right.
Thank you.
Yes, go ahead.
Thank you, Sato, for the overview of the work of the committee. I will now quickly take us through the major observations, findings, and recommendations made by the committee, which are contained in the executive summary. We were able to make about 14 observations and findings based on our work, and I would like to share some of those findings with the committee. First, to say that our major findings and observations were that, one, that when COVID-19 was declared a pandemic by the WHO, The federal and state governments adopted various measures to control the spread of the virus, some of which inadvertently resulted in disruptions and wide-ranging ramifications on access to justice and justice delivery in the country. The lockdown, curfews, and other restriction of movements imposed across the country caused disruptions to the smooth functioning of the justice system, altered the behavioral patterns and work ethics of its personnel, and generally limited the level and mode of justice delivery to the populace in the country. 3, we also observed that the sector also witnessed apparent denials and delays in justice delivery, particularly with respect to awaiting trial persons, as well as other correctional trials was stalled due to the suspension of physical court hearings in response to the COVID-19 pandemic. Also, we found out that lawyers in Nigeria were not categorized as essential workers during the lockdown, curfew, and other restrictions of movement occasioned by the pandemic, and therefore they could not easily ply their trade and provide legal services to persons in need during the period. Another finding made by the Nigeria and outside Nigeria responded to the pandemic by leveraging on technology to minimize physical contact with judges, court administrators, court users, lawyers, and litigants by embarking on remote hearings, e-filing of proceedings, e-payment of processes, and so on. And that the National Judicial Council and the various heads of court had, in response to the COVID-19 pandemic and other various measures imposed by federal as well as state governments to control the spread of the pandemic, issued practice directions and guidelines to reinforce social and physical distancing protocols, sanitation, suspension of physical court hearings in respect of matters that were not considered urgent or time-bound, and approved protocols for remote hearing of cases. Also, we found that the approval of remote hearings by the practice directions issued by the respective heads of court has generated controversy as whether such hearings satisfy the requirements of Section 36, subsection 3 and 4 of the Constitution of the Federal Republic of Nigeria, 1999, which requires hearings by courts and tribunals to be held in public. Another major finding was that in response to the UN, advice by the UN and the directions of the President and the Chief Justice of Nigeria, measures were taken to effect conditional and unconditional release of awaiting trial inmates to complement existing obligations under relevant administration of criminal justice laws applicable at federal and state levels, aimed at reducing and reducing the population of awaiting trial inmates in correctional facilities. We also noticed that the pandemic will affect the obligations and diverse timelines in contracts which departments and agencies of government were negotiating with local and foreign investors prior to the outbreak, that the pandemic may also occasion delays in the negotiation and execution of bilateral, regional, and multilateral agreements, and in some places, breach of treaty obligations. The committee found that the losses suffered by foreign investors in various sectors due to government measures in response to the pandemic may create room for investigation for economic losses suffered during the period, and it will be difficult to state if governments will be sufficiently insulated for the measures taken, or that the investors will be sufficiently indemnified for the substantial losses during this period. So after making these key findings and observations, the committee made some key recommendations, which I will also briefly take us through. There were 15, but I'll just take us through the major ones. The first key recommendation we made was that the justice sector should leverage on technology to deepen e-filing and e-payment for processes, e-service of court processes, and virtual or remote court hearing in appropriate cases. That this will ensure continuous hearing of cases during the pandemic and beyond COVID-19 in order to improve access to justice and timelines in the dispensation and timeliness, in the dispensation of cases. We also recommended that this calls for massive investment in ICT infrastructure needed to mainstream and institutionalize effective remote proceedings and electronic filing of processes as recommended. Our third key recommendation was that to ensure uniformity in practice, we recommend that heads of courts should, in issuing COVID-19 practice directions, adopt and incorporate the National Judicial Council's guidelines for court sittings and relevant and related matters in COVID-19 period, issued via circular number NJC/CIR/HOC/266 to guide the administration of justice during the COVID-19 era as a minimum before proceeding to make necessary additions to accommodate innovations that are peculiar to those courts. Another key recommendation was that the justice sector collaborators should create more e-platforms and hotlines for victims of violence and sexual abuse to send distress calls for speedy intervention, because like we noted that many of these vulnerable groups do not have access to justice or even law enforcement personnel during the pandemic. Should take a lead in trying to forge a national consensus on this matter. We also recommend that the Nigerian Bar Association should be encouraged to adopt the use of electronic stamps and seals for use by legal practitioners in place of the stamps that manually affixed to processes and documents today. This will facilitate filing of processes documents. We also recommend that all agencies involved in the provision and management of justice sector should adopt a collaborative effort towards implementing the national judicial policy with a view to utilization of effective administration of justice. In this regard, we also recommend
Professor Peter, hold on, please. Kemi Omadanisi, please, you are interrupting the presentation by the lead presenter. Kemi Omadanisi, take your family and your background. Please mute yourself. Thank you. Professor Peter, please continue.
Thank you, sir. So we also recommend the Honorable Attorney General of the Federation and Minister of Justice should direct all MDAs to review all their treaty and contractual obligations to determine the effect of COVID-19 on such treaties and contractual obligations. This is to ascertain whether there is need to renegotiate price, payment terms, and deal with delays that would have, or even breaches that would have occurred as a result of the COVID-19 pandemic. So, Honorable, the DG, sir, these are the major
Professor Peter, yes, please, the last 2 minutes, you were not audible. Can you mute yourself and repeat your concluding remarks? Professor Peter, the last 2 minutes, your concluding remarks, please. We didn't hear you. Yes, Professor Peter, the last 2 minutes, concluding remarks.
Yes, sir. Sir, yes, I said I would yield my microphone to my colleague and co-chair, Professor Adebambo Adewako, Senior Advocate of Nigeria, to specifically deal with terms of reference 1 and 2 of our report, sir.
Okay, the floor is his.
Thank you, DG. Thank you, DG. My dear colleagues, thank you. It's a pleasure to be here to speak specifically to terms of reference 1 and terms of reference 2. I will just go straight to the terms of reference. Terms of reference 1 is focused on the impact itself, the impact of COVID. I will use the word COVID for short. The impact of COVID on the justice sector and the administration of justice. Now, the point has been made very clearly without any range of measures or interventions from all over the world, from governments from all over the world. In Nigeria, both federal and state authorities. These measures are contained in the respective presidential address and with particular reference to justice sector, different guidelines, practice directions, circulars, policies by the office of the CJN, state heads of court, office of the Attorney General, and clarification. Justice sector comprises, and you will see this in the report, justice sector comprises a whole range of institutions and activities and actors responsible for the for provisions of justice sector services and administration of justice. Courts, of course, courts, correctional facilities, law enforcement agencies, including police, practicing bar, lawyers in public employment as well. Now, our finding in terms of impact, Professor Akpe SAN has made allusions to some of them, but I will look at the key ones. Number one, the impact has wide-ranging impact for the sector, which relies on considerable physical mobility and contact to perform functions. For instance, the lockdown and restrictions of movement, physical court sittings were suspended, except in some instances. Remote sittings were introduced. Law officers, both state and federal, who are charged with responsibility to prosecute cases, were unable to carry out their functions as a result. And there we observed, or we found there's a risk of congestions in correctional and custodial centers, especially in cases awaiting trial persons. Disruptions in case management by the courts. And of course, access to courts was severely disrupted, with effect on access to justice, having effect on access to justice, howsoever defined. We had high incidence of police brutality, and we had reports of domestic and sexual abuse, which of course have also resulted in restricted access to seek redress. The practicing lawyer could not provide legal services, which has resulted in loss of income by the lawyers, particularly the young lawyers, of course, both the young and the old. There were delays in enforcement and execution of court orders and judgments. And we also observed contractual obligations. Professor Akpe made allusions to that. Contractual obligations were severely affected, with very high prospect of invocation of force majeure clauses in those contracts if they exist in any of the contracts and properly defined to cover the emergency engendered by COVID. Now, I'll go to key recommendations. We made quite a number of recommendations, as Professor Akpe said, but I will just look at key ones with respect regards to the impact. And of course, one on leveraging on technology is very paramount. It's probably number one, that justice sector must leverage on technology, which the emergency has brought about. For example, the issue of remote hearing of cases in carefully defined situations. For instance, in pre-trial stages, in the delivery of judgment, or in the hearing of non-contentious cases. And of course, there are other cases that has become very controversial, which is the issue of constitutionality of remote hearings in the light of section 36, sub 3 and 4. That we have recognized in our report. Then we also recommend enhanced investment in ICT infrastructure.
Please, can you put on your webcam so that we can see you on the screen?
Yes, I'm handling that. I have some issues. I will do that. Yes, I will do. I have issues with that. I will do that right away.
All right.
Yes, DJ.
Okay.
So enhanced investment, we recommend enhanced investment in ICT infrastructure in order to mainstream electronic administration in the justice sector, such as e-filing, e-payment, and the rest. Then we also recommend the maintenance of an appreciable level of uniformity of practice. We observe fragmented guidelines and practice directions coming from different directions, Office of AG, Office of the CJN, either in that capacity or in the capacity as chairman of the Judicial Council and all of that. So we recommend some measure of uniformity of practice in order to put all of this together in the proper context. We also recommend further decongestion. We recognize the presidential directive in that regard, but we recommend further decongestion of correctional and custodial facilities. We also recommend sensitization and training of law enforcement agencies, particularly in the post-COVID era, with particular relation to human rights issues, human rights considerations, and human rights implications of some of the actions regarding enforcement of the measures. Then, of course, we recommend more funding of the justice sector, particularly in view of the increased cost implication for administration and delivery of justice in the post-COVID era. These are some of the key recommendations that we thought we should bring to your notice in this forum. I'll go straight into the terms of reference number 2, which addresses specifically states in the DG's directive for us to document innovative interventions that are relevant to the sector within and outside Nigeria. Actually, the global effect of the pandemic has brought about a diversity of interventions globally and across justice sectors in different jurisdictions. Sometimes they are the same, sometimes they are similar, sometimes they are different, all with the purpose of, with the goal of adapting or adjusting to the disruption brought about by this pandemic, with particular reference to justice sector. Now, again, I will refer to the various measures that we have mentioned without repeating them, all the various measures that we have alluded to that are basically to enforce anti-COVID protocols or anti-COVID interventions for administration of justice and the justice sector as a whole. Now, we went through a whole volume of measures outside of the country. We went to Europe, we went to the US, we went to Europe and 1 or 2 African countries. I will just summarize that without going to specifics, and you'll find that in the report. For instance, in the US, we find that the federal courts and the district courts restricted and suspended court sittings across various courts, and they also reduced access to the public, to the courts. We found that the US, they expanded citations, what they call citation, to limit arrest, of course, without prejudice to the very controversial George Floyd case that's all over the world. But there is an expansion of the citation to limit arrest. There's also release of deserving cases in order to decongest jails and prison. And much the same we find out in the European courts. For instance, in Estonia, in Luxembourg, in Australia, no, in Austria, in Italy, we found out that, in fact, in Estonia, I must mention distinctively here that the courts were open. The courts were open; they were never shut, but with reduced hours of sitting. And I think that's something that we brought out in that context. And of course, some of the European countries, you have suspension of computation of limitation periods, which includes time within which to file appeals. In the UK, particularly, there was an authorization of remote hearings, and particularly the UK government permitted live streaming, and I think this is very instructive to Nigeria. UK permitted live streaming and simultaneous broadcast to the public and the media. And I think that's very instructive. Back home in Africa, in Kenya, the National Council on Administration of Justice drastically reduced public access to courtrooms. And there is a very, very instructive point from Kenya. They also allowed parties in civil matters to consent to dispense provisions requiring judgment or rulings in open court. Consent provisions were enforced or were allowed in that context. Now, recommendations, again, leveraging on technology comes in very handy. In the justice sector, we are in a time where the justice sector can no longer run away from application of technology in the administration of justice. And closely related to that would be to invest heavily in improving and building capacity to achieve that. That's very strong in our recommendation. And of course, that will result in enhanced funding of the justice sector. And we also recommend that future interventions as the COVID impact of COVID continues, that future interventions should be timely, should not be too reactionary, should be timely, should be proactive, should be dynamic, and should be constantly reviewed to address matters arising, conditions and situations arising in the course of time. We also strongly recommend the upholding of human rights and rule of law in interactions with citizens. And we have seen that some of these measures are similar across board worldwide, and Nigeria is not an exception. We have emphasized the application of technology very strongly across recommendations without necessarily going to the other TEORs. And I will stop there for now with particular reference to terms of reference number 2. Thank you, DG.
Thank you, Professor Adioko SAN, co-chair. I will now allow members of the committee, Professor Peter Akpe, please. Can you identify who is next? They will actually take the floor for only two minutes, please, so that we can open the floor for discussion.
Yes,
only 2 minutes. Only 2
yes,
minutes.
DG. Professor Paul Idonije, Senior Advocate of Nigeria, will take us through terms of reference 3 and 4, and then we'll be ready to take other specific issues as they arise. But in terms of completion of presentation of the report, terms of reference 3 and 4 need to be presented by Professor Paul Idonije, sir.
Okay, the floor is yours, Prof.
Yes, DG, good afternoon. Good afternoon, everybody. I'm glad to be part of this committee. Without me to praise what we did, I think that our chairman has ably presented a summary of our main recommendations. Now, my task is to look at the term of reference 3 and 4. In 3, the committee is to articulate practical policy-oriented recommendations to the Honorable Attorney General of the Federation and the Honorable Chief Justice of Nigeria, as well as the NBA President, on how best to implement national judicial policy adopted in 2019. Term of reference 4 is the omnibus term. It's for us to make any other recommendations to appropriate authorities in the judicial sector. Now, I will start with term of reference 3. Like I said, Cameron has done a good job in this presentation of our summary. So by way of a background to how we arrived at our recommendations, we found that we already have 3 main policy instruments in place. The first one is the National Judicial Policy formulated by the National Judicial Council and National Judicial Institute pursuant to their constitutional and statutory powers respectively. The second policy document is the National Policy on Justice, which is the outcome of the work of the Presidential Committee on National Policy on Justice, which was approved by the Federal Executive Council in 2019. The third instrument that we use is the Nigerian Information Technology Policy, which outlines reforms for the application of information technology in the judiciary. So as you can see, the judiciary is already articulating how to apply technology to their work. Now, if I briefly summarize what is in these 3 main instruments, the National Judicial Policy is an amalgam of sub-policies related to judicial officers, highlighting appointments, discipline, code of conduct, education and training, performance, access to justice, case law management, transparency and anti-corruption, judicial independence and collaboration. Now, the National Policy on Justice aims to provide the sector a platform of it to cooperate and collaborate towards achieving the following: effective and efficient justice delivery, enhance socio-economic development within the context of the Sustainable Development Goals, harmonization and integration of the various justice sector initiatives into an all-encompassing document and cuts across all sectors and departments, as well as civil and criminal jurisdictions. jurisdictions. Now, the National Policy on Justice contains 70 thematic areas, each highlighting a specific issue, identifying challenges, and stipulating strategic interventions. We found that these strategic interventions are still relevant. Now, these first two instruments, i.e., the National Judicial Policy and National Policy on Justice, are two of the most outstanding policy documents regulating how the justice sector should operate. As the most recent and only policy document adopted in 2019, the committee focused on the National Policy on Justice, particularly as the impact of COVID-19 on the justice sector affects several other sectors, including health and information technology, which are highlighted by the policy document. Now, let me quickly look at our findings. Any option that will adopt information technology. Now, on this, a lot has been said, but we want to discuss certain things. First, it's not enough talking about adopting information technology. Now, which technology are we talking about? Which platform are we going to use? We need to address issues of cyber security. We need to address issue of confidentiality. Zoom, that is commonly used. There are reports that there are hackers. So how do we ensure that there is cyber security? So it's not enough, like we said government should ensure that in a particular platform, all these stuff must be taken into account. Now, we found that there are collections of policies, circulars, guidelines, practice directions, which in various degree are meant to enforce and strengthen the justice sector. We also found that the thematic areas referred to in the National Policy of Justice include review of requisite legal provisions, adoption and enforcement of emergency measures, welfare and well-being of people living with disabilities during the pandemic, welfare and well-being of migrants, IDPs and refugees, right of persons to privacy and duty of confidentiality for medical personnel. Now, references have been made to policy directions issued by the Honorable Attorney General and the Chief Justice of Nigeria. But I must understand that with the regulations that were promulgated by the President pursuant to his powers under the Quarantine Act to address the health challenges arising from COVID-19, which has impacted on physical court sittings. And we think that these challenges must be addressed. Now, like I said, there have been various policy instruments have been addressed by my chairman and vice chairman. I don't intend to discuss them any further. But our position, like I said, is these three policy documents, among others, provide a framework to address the issues arising from COVID-19. Now, the recommendations, again, these are part of the executive summary, which has been addressed by our chairman. I don't need to dwell on this. But I need to talk about this issue of the implication of Section 36, Sub 3 and 4 of the Constitution and the bill before the National Assembly. There was a report this week that the Lagos state government has sued the federal government on this, and they are challenging the competence of the National Assembly to amend the Constitution we believe that the Honorable Attorney General of the Federation take a lead on this matter. We feel strongly on this, that there's the need for a definitive statement, more so that there are judicial pronouncements on the meanings of public referred to in Section 36, Sub 3 and 4 of the Constitution. So is virtual hearing public? So unless there's a judicial pronouncement on this, we will have different interpretations as to whether virtual hearing is constitutional or unconstitutional. Now, there's a need for training. There's a need for training. Technical training, capacity building for judicial and non-judicial officers. This is very important because even if we get it right, appropriate technology, appropriate platform, but the users lack the capacity training to use them, then it will be of no use. So we are advising that government should make efforts to ensure that the judicial sector is properly funded. Now, we observe that we are never short of policy instruments in this country. There are several of them, but is the implementation. So we think that if these three existing instruments are implemented, then we are a long way in solving the problems arising from the COVID-19 pandemic. That is the end of my summary of term of reference 3. Now, as I said, term of reference 4. Yes, DG?
Please.
1 minute. Okay.
Yes.
Okay. Well, what we observe in terms of reference 4 is that Nigeria has entered into various contracts. Nigeria is negotiating various contracts. Nigeria is a party to several treaties with all kinds of obligations. We think that as a matter of urgency, the Honorable Attorney General should ensure that all these contracts and treaties are examined to ensure that we will not be in default. In terms of contract, to ensure that there's no breach. If contracts require negotiation, that should be done immediately. If a treaty needs to be reviewed, that should be done immediately. I think that is our main recommendation on term of reference 4. Thank you very much, DG, and like I said, I'm glad to be a part of the team.
Right, Professor Paul, thank you very much for your presentation. Chairman Professor Peter Akpe, can you introduce your other members of the committee to take the floor in just a minute to 2? To please emphasize on areas or issues that were never actually pointed out by the former speakers. The floor is yours. Members of the committee, please take 1 minute each. Yes. Professor Emily Alemika, Professor Animi Awa, the floor is open for your intervention, please. Professor Animi Awa, Professor Emily Alemika, Dr. Ibe, if you have, Dr. Ibe, and then please, you have 1 minute to take the floor. Unmute yourself.
Good afternoon, everyone.
Good afternoon. Yes, go ahead. Yes, Professor Emilia, you are not audible.
Okay. Thank you.
Yes, we have 1 minute. Go ahead.
Okay. Can you hear me?
Yes, we can hear you. Go ahead.
No? Okay. Thank you very much. Okay.
thank you for giving me the opportunity to share my view. I just want to say that on general note, the committee that was set up, blessing in disguise, that revealed so many things that ordinarily have been taken for granted, especially the issue of virtual court sitting. We discovered that there are so many provisions that have been made, which the court or the judiciary has not taken any serious approach to bringing all this online or digital session of the court. So we feel that this is a blessing in disguise, because the COVID has been able to accelerate bringing virtual courts to being. The area, of a prospect that have been seen, you can see that some of the courts process can be amenable to virtual sitting, as we are seeing today. Although there are others that may not be so amenable, but we can say like originating someone and service or process and the rest of it. We have been able. Possible. But we didn't talk about we didn't talk generally about the challenges, but we, in the course of our meeting, we discovered that some provision of the court, of the Nigerian constitution, like section 36, that has to do with public hearing and the rest of them. But we know with time, we'll be able to overcome that. But there are other challenges too that generally will affect those of the litigants, the counsel, and so many other courts, people that are to interface. But I think with time, what we recommend is that, like my colleague has said, we will overcome when we get there. But as far as virtual hearing is concerned, I think it has come to stay. And the only thing is that we hope that so many areas like the training of the judges, the courts staff, to be able to make this virtual hearing more efficient is needed at all times. Thank you very much.
Thank you, Prof. Professor Animi Awa, Dr. Ibe, please, you have 1 minute each so that we can open the floor. Dr. Ibe, Professor Animi Awa, please take the floor. 1 minute each, please. We have Professor Momodu, Professor Abiola Sani, Dr. Bello Fadile, the Professor Asim Balarabe, all trying to actually make some input after your intervention. Please, you have a minute each. Members of the committee, please.
Can I come on board, please?
Yes, go ahead, Dr. Ibe.
Okay. Good afternoon, Good afternoon, DG. Good afternoon, professors. Good afternoon, colleagues. I just want to say that I'm really happy to be part of this project. And because so much has already been said and a lot has already been covered, I will just say one thing, that in general, that what the report itself and the presenters have done is basically to keep justice in sight. This is so because the report is saying that access to justice is crucial, it is critical. So if really we want to achieve fair and speedy dispensation of justice for all at all times, including this pandemic period and beyond, and if we are saying that entrenching access to justice for all has to be achieved. And if we say we have to promote ADR, restorative justice, and other correctional measures, and better our system, our justice system, and if the justice sector is to function effectively in enhancing national security or facilitating economic growth and engendering sustainable justice, then a lot must have to change. So several findings attracted, in fact, a series of recommendations which have already been highlighted by the presenters. But let me just say that the recommendations made to guide government and justice sector leadership, as well as societal responses to future emergencies, are not short-sighted or even narrow. So the recommendations, if I may compound, point to the need for responses to the comprehensive in approach and on the basis of human rights, justice as well. And solutions profiled in the report aim to prevent violence and improve social harmony and increase access to justice and affirm the general public's sense or notion of justice and fairness and dignity. So more importantly, the entire report shows the steadfastness and commitment with which NIALS approaches national issues, especially in enhancing a better justice system in Nigeria. So for the next, in fact, for everyone, especially the vulnerable people, and it is the solutions profiled are wonderful, and like the presenters already stated, if they can be effectively implemented, I think the Nigerian story will change and we will find ourselves moving to the next level in terms of justice delivery. I thank you all. Thank you.
All right, thank you, Dr. Ibe. We'll now open the floor for comments, questions and answers, particularly.
Sorry,
yes.
Sorry, sir. It's as if I've been forgotten, Dr. Azad.
Okay, he has 1 minute, please. 1 minute only.
Thank you very much, sir. Yes, sir. I think that the judiciary must come to acknowledge the importance and role of technology in the administration of justice. We shouldn't wait until the outbreak of a pandemic before we begin to think about the application of technology in administration of justice. And interestingly, in the Nigerian Judiciary Information Technology Policy of 2012, the importance of video conferencing was actually emphasized. And taking leave from other jurisdictions, in America, as far back as 1988, 1990, and so on and so forth, they have been deploying the use of technology in their court hearings. And I think that we must not be lethargic as a country in pursuing the application of technology. Technology has come to stay. The world is now being driven by technology. And I think that we must be proactive in our approach to application of technology in the administration of justice in Nigeria. Some of the arguments that are being canvassed here and there is the difficulty in deploying technology in court hearings. But I want to take a cue from the words of Lord Denning in Parker versus Parker, way back in 1954, where he identified the need for the law not to stand still and watch the world move on. And Lord Denning said, what is the argument? That no case exists where it has been done. And he said, if we continue in that way, the world will move on while the law still stands still. And I think that we must be innovative and creative in the administration of justice in Nigeria, so that we can also improve our justice delivery. Interestingly, the dictum of Lord Denning was actually applied in Nigeria in 2012 in FRM versus Fani Kayode. But regrettably, no steps have been taken since then to try to deploy technology in the administration of justice until the outbreak of this pandemic. And I want to conclude by saying that the judiciary, as a nation as a whole, we must actually improve in our innovations so that we improve our services. Thank you very much, sir.
All right, Dr. Azad Abila, thank you for the intervention. I would like to give priority to our external participants outside, actually, NIALS, and both within and outside Nigeria. On the list, there are still actually they are still alive with us. Is Professor Abiola Sani of Unilag, Professor M.K. Momodu, Professor Timothy F. Yarima, Professor Kasim Balaribe from India, Dr. Bello Fadile from US. Please, any one of you that is still actually take the floor for 1 minute. Dr. Bello Fadile from US, Professor Kasim Balaribe from India, then Professor Abiola Sani, Professor Momodu, Professor Yarima, and then Barrister Usman Ibrahim from NILS. Please, the floor is open for 1 minute before we return back to NIAL staff.
Yeah. Hello, my DG.
Yes, Professor Abiola Sani, introduce yourself, please.
Yeah, good afternoon. I sincerely commend this initiative. I mean, having a reliable report on what has happened is going to be extremely useful for researchers. I mean, these are verifiable information which will form the basis of future research initiatives. Having said that, we need to take cognizance of the fact that investment had been made on technology with regards to court hearing. I know a lot of, at the state level and the federal level, we've been told that we can do certain things online, we can file cases online, we can make payments online, and even up to the Supreme Court. So there must be an assessment of the extent to which stakeholders are familiar with this and leveraging on it. Because if these infrastructures are there and they are not being used, there are money gone to waste. So that is very, very important. And I'm also concerned that since the first week of May, when the NJC made this rule, I'm not aware Supreme Court had leveraged the virtual hearing guidelines. Since this was signed by the Supreme Court, by the CJN, I expect the Supreme Court to lead from the front. Because if the Supreme Court had organized virtual hearing, then it can be seen as a validation of virtual hearing. But if there is a regulation that they have never used, then that is going to give room for skepticism on whether they even believe in it, on what the outcome of any litigation on the constitutionality of virtual hearing may be. And I hope we will have a link to the replay of this webinar at some point, and also the report itself. Thank you very much.
Thank you, Professor Abiola Sani from the University of Lagos Faculty of Law, a distinguished professor of tax law. We can assure you that the copies of the full report will be available not only to the Attorney General, CJN, and the MBA President, but we'll also actually share with deans of law faculties, and then we'll post them on our website for access, by all across the globe. So Professor M.K. Momodu, Professor Timothy Yarima, Professor Kasim Balaribe from India, Dr. Bello Fadile from US, please, if you are around, take the floor for a minute each.
Can I have the floor, sir?
Please take the floor, Dr. Bello Fadile from US.
Thank you very much, Prof. This is a good initiative. First of all, in challenging the challengers, we have to be very careful in generalization. For instance, the court system in America are two parallel court systems. So you have the federal courts consists of 4 courts, And then you have the state cost that varies from state to state. Again, an example of virtual hearing in Harris County, the third largest county in America, there was a disagreement between the judge and the president of the county in who to release as a result of COVID-19. That's one point. Point number two, we need court technology, not just technology, court technology. They are peculiar to court system, it's not general. Point number three, Professor Dinije raised that issue, cyber security. How do you prevent, for instance, in a criminal trial, the defense coaching the witnesses? We now have to go, how do we practicalize what we are talking about, the theories the committee has. For instance, look at training, just look at how we started here and the complexity we have in linking up or in using this system we are using right now. Now you can now go down to a level lower than our own understanding in terms of technology, the chief clerk, the chief registrar, the reporters, the litigants, the witnesses, the prosecutor, and the defense counsel. And then most importantly, which point I want to talk about is the recording of the proceedings. You want to appeal, how do you get the recording? Can you get it within 2 days? How do you prepare? How do you practicalize all those things? Those are the few points I want to bring to your attention. Don't overgeneralize. America, courts, the system and the federal court system is different from state and different from state to state. Thank you very much. I will intervene if there is need or question on what I have said to elaborate more, so that others can come.
Thank you, Dr. Bello Fadile. Dr. Bello Fadile is a retired colonel and a former director in the Office of the National Security Advisor. He's in diaspora right now. Come back home. Prof, thank you for those explanations and also for your advice. Noted. Professor M.K. Momodu, Professor Kasim Balarabe from India, and Professor Timothy, please, a minute each. Take the floor.
May I go on, please?
Yes,
can you hear me?
Yes.
Okay. Good evening, everyone.
Good evening.
My name is Kasim Balarabe. I work with Jindal Global Law School of OP Jindal Global University, based in Sonipat, India. I thank you very much for this work and for the wonderful contributions you have made, especially to the justice sector regarding what needs to be done and the approaches that should be adopted in order to ensure that there is access to justice and also some of the fundamental problems of concern are addressed. But I have some concern. As Professor Emile has mentioned, that this is a blessing in disguise for Nigeria to get its acts together. And as also Professor Paul has mentioned, that there is no paucity of policies in the country, but the issue is that of implementation. And that is really where the problem is. You'll find that in Nigeria, we keep on making beautiful speeches at various fora, national and international. But when we get to where the real issues are to be handled, then we go into hibernation and nothing will come out of it. And the policies will just go there and you will never know that they exist until something very dangerous occurred. And then we go back to see and check that we do have something that will address that if only we had checked. So really, I hope that this will be a game changer for the country in terms of how Nigeria handles its affairs, especially in relations to justice sector and also in guaranteeing access to justice. We have noted in the course of the pandemic that there are serious issues of concern, like the issue of brutality of law enforcement agents in the country, the issue of funding of the justice sector. At one time, for some years, I worked with the Federal Ministry of Justice, and I know how difficult it is for innovations to pass through because of funding. So while on the one hand, there is a pressing need for things to change and for the country to have a refocus on what really matters, there is also a concern that the issue will be glossed over after the pandemic is over, that we may not even go back to it. So my call is on the relevant authorities here, the concerned authorities here, that they should try to see that they push these very wonderful recommendations that have been made to be pushed to be implemented in a more pragmatic way for the country to move ahead. It is not that we really lack the resources or the technical know-how to address our difficulties, but it gets, people get very angry when they know that we have all these resource persons in the country, we have all the resources that are needed to address our concerns, but then you hear us going to other countries begging for assistance when in fact we can actually address our concerns. So that is my little contribution to this. Please, the authorities concerned should push these things through to see that real concrete issues are addressed, not just we will wait until another pandemic comes and then we begin to think of what to do again. Thank you very much.
Thank you, Professor Kasim Balarabe from India. We are grateful. I know when you left the Ministry of Justice to National Commission for Refugees, from there you disappeared to Uganda, Netherlands, and then you ended up in India. Well done. We've noted your concerns and your advice, and we can assure you that already, in fairness to the Federal Ministry of Justice, I noticed Professor Larry Chukwu has joined us. Barrister Osman Endurance from Ministry of Justice has also joined us. These are members of the National Justice Sector Implementation Committee, and these actually members have noted some of these issues, and we can assure you that the report will actually be fed into a national implementation strategy for the national justice policy. All right, Professor M.K. Momodu, Professor Yerima, please, if you're around, Professor Larry Chukwu, one minute each, please. One minute each.
Thank you very much. This is Momodu, Kasim Momodu.
Okay.
Just what I want to quickly add is this has taken us by surprise. I agree, we've had these policies that have been mentioned since 2012 and 2019, but COVID-19 came in all of a sudden. And I must say we haven't done very badly at all with what we've done so far. Without preparation, without any training, we've been able to do the little we've done, but there's still a long way to go. As it is, things are not going to be normal again. Let's not deceive ourselves. We are in for a very long haul. So the National Judicial Institute has to wake up. There need to be training. Don't forget, when we talk of courts, you start from the magistrate courts up to Supreme Court. Supposing we have a recurrence tomorrow or next year, and it's worse than what we have now. So we should be thinking of training and retraining, not only of the judicial officers, but also of lawyers. Another issue to look at is national bandwidth. Even with the discussion we are having, sometimes you are not able to communicate well. That problem will be there. We are still arguing over 4G or 5G. The real technology part of it has to be looked at, and whatever the government can do to be sure that our bandwidths are stable, we have to do. I think that's the little that I want to put in here. I would have talked about arbitration because I have been involved in 2 arbitration hearings, 2 different arbitrations, virtually since this started. Something we never thought could happen. Suddenly we find ourselves, I sit in my library in my house as an arbitrator. The other 2 arbitrators are in different parts of the country, and the councils are in different parts of the country. It's amazing. And we've gone on successfully. So there is a lot to benefit from COVID. Of course, we don't want people to die. We don't want people to be sick. But it has opened our eyes, and we just have to do the best we can to make sure that the advantages that it throws on us in terms of improvement in our processes, we don't let it go. Thank you.
Thank you, Professor Mamadou. Next on the floor, we're expecting to join us, take the floor, is Barrister Usman Endurance from Ministry of Justice, or Barrister Usman Ibrahim from NILS, or Professor Larry Chuku from University of Abuja. 1 minute each, please. There are Professor Timothy Yerima, if still around. And Dr. Erima, if you are still ready. 1 minute each, please. The floor is open. Yes, the floor is open. Next, Dr. Erima, Professor Larry Chuku, Professor Timothy. All right. All right, so the floor is open to all. I can see our two former DGs, Professor Deji Adekunle and Professor Meze Bobadia. The floor is open. 1 minute each. Professor Deji Adekunle. The floor is open. The floor is open, please. Okay.
Hello. Good afternoon, Prof.
Yes, take the floor. Go ahead. Usman and Joran.
Sir.
Yes, take the floor.
I just want to chip in a point there. I think, first of all, let me congratulate the committee for a job well done. I think we should also look at very shortly what will happen in the post-COVID period. That period is a period of open economy, and we expect boom in activity, although in a new formal way.
In the next 2 minutes.
So we are like to have for one of the presenter or discussant mentioned that there are platforms and structures for filing of cases and paying of fees. But the truth is that most cases are not going on. So in the post-COVID period, we are going to have crisis of managing of all cases. And if the open period, other the post-COVID period is an open economy period, and we are likely to have boom in activities. It therefore means that we are going to have, I'll say unprecedented number of cases, new cases. So we are going to have problems. So I think we should look at what will happen really after the post-COVID period. It's a new normal. We are going to have more cases to handle, and of course more cases to also handle. I will quickly suggest that we think of either appointment of judges is not going to be very easy. The process is cumbersome and it takes a lot of time, and there's cost implications. So probably maybe the judiciary should start thinking of adjunct judges just coming for to temporarily assist, and they could pick adjunct judges from retired judges, from academics, and from maybe practitioners who are not involved in the cases. And of course, there should be a strong, maybe strengthening the ADR process. And of course, we should also think of community adjudication. Simple matters could be settled at the community level. That would really help, us address the crisis that we are going to have in the post-COVID-19 period. So, like I said, my perspective is because we are going to have a lot of cases to handle, old cases, and the boom in activities after the open economy will also bring new cases. A lot of cases will be filed. The structures we have now are just for payment of fees and filing of fees. Even as yesterday in Lagos, they are not starting a date for all cases. So it's going to be a lot of crises. So if we don't think of how to get adjourned judges and adjourned magistrates, we may really have a lot for them to contend with. That's the little I can say for now. So my advice for the committee is to also look at what will happen at the post-COVID period, which is an open economy, though booming activities and of course a new formal way. Thank you, Prof.
Okay, thank you, Professor Emmanuel Okon. Yes, another person can take the floor. 1 minute each, please.
Okay, can I have the floor, Prof?
Yes, Barrister Osman Endurance from Ministry of Justice. Please take the floor.
Okay. I want to first apologize for not joining the meeting early enough. I was engaged with some activities in the office. Just to say that I heard Learned Prof. Paul mentioning that although he acknowledged the effort made by the Federal Ministry of Justice together with stakeholders to develop the National Policy on Justice 2017, and as well as the approval secured by from the Federal Executive Council to that effect. However, he mentioned that it was not certain areas that were omitted. I want to say that as a member of the technical committee that developed the policy, we took into cognizance the fact that we cannot, the whole problems that confront the justice sector cannot be articulated in just a small document. And that's why there's a provision for the review of the policy every 5 years, and which will be due in the year 2022. So in that case, those other areas such as protecting, considering the disabled and all that was mentioned by Prof will be taken into consideration. Thank you, Leonard Prof.
All right, thank you, Barrister Usman. Usman, you've not mentioned one thing, to also respond to the same issue or concern raised, that we are currently, as members of the National Implementation Committee, we are currently developing an action plan of the National Justice Policy. So what the policy itself has not captured, the implementation action plan, can actually provide some nitty-gritty specifics to accommodate some of these things. So we are still actually on course before the review period every 5 years. All right, the floor is still open. Thank you, Usman. The floor is open. Another person that wants to take the floor, 1 minute each, please. The floor is open. Dr. Erima, Dr. Uwem, Kemi, Ire, yes, the floor is open. Fatima, the floor is open. All right.
Can we make other comments?
Yes, Professor Sani, go ahead.
Oh, okay, thank you very much. I'm interested in the linkage between virtual hearing, technology, and corruption. For me, all the bottlenecks, administrative bottlenecks leading to some payouts, which may be expedient but are totally unjustifiable, will be a thing of the past, hopefully. So why this will eradicate some forms of corruption, we should expect corruption to rear its head in another form. So we need to anticipate a likely manifestation of corruption in the system and then prepare ahead for them.
All right. Point well noted. I think in fairness to the ICPC, Anti-Corruption Agency, and also very recently in the context of COVID-19, in fact, to be specific, just last month, surprisingly, Code of Conduct Bureau decided also to mount its strategic plan of action and work plan, on addressing, corruption and abuse of power or office, in the national response measures to COVID-19. So, believing that they may also unravel some of these concerns that Professor Abiola Sani just raised. But I think it has to be well articulated as a national strategic policy framework. So let's see how it goes in the implementation of the national policy on justice and the national strategic policy on technology. Thank you. Any other person that wants to take the floor? A minute each, please. The floor is open for questions, answers, or comments. All right. I'm going to give the chairman of the committee or any member of the committee the opportunity to respond in just 2-3 minutes or clarify 1 or 2 points. Except if there is a participant that wants to take the floor for a minute. All right.
Yeah, Digi, thank you very much. We want to appreciate the contributions made by the participants, particularly from outside of the institute. The points made by Professor Abiola Sani is very apt, i.e. the fact that certain courts in Nigeria have started implementing the use of technology in their processes. The point is how deep has been the use of this technology in those courts. And so there's a need for us to carry out an assessment really to see the extent to which this technology is being applied in those courts. I know the National Industrial Courts started this process very long ago. Other courts have also joined, but what is the extent of use? That is what needs to be determined. So I believe that an assessment would give us some clarity as to how we're responding to the use of technology in these courts. But you can see that is why in our recommendation, we talk about leveraging on technology. That is, we should leverage on it because of the advantages that it provides for both court users, the judges themselves, and litigants and lawyers as well. So I think it's a comment that's well taken. The comment made by Professor Fadile, Dr. Fadile is also quite apt. That when we talk about leveraging on technology, it's not just every technology, but of course, court-related technology is very important, although that also dovetails into the larger technological ICT infrastructure that you have in the country. The issue of cybersecurity is a very strong concern. If documents are going to be filed online and then received online, even judgments delivered and so on, we have to ensure that our cybersecurity is such that we can actually guarantee the integrity of the documents filed, and also that someone will not just hack in and maybe redact certain documents and so on. This is a concern that most of the committee also looked at during our presentation. Now, Professor Balarabe's comments that Nigeria has implementation challenges, one that no one can ignore, except if you are not in this milieu. So we do understand that these recommendations that we have made we pose some implementation challenges. But the point to note for us, and when we are making this recommendation, is that that should not deter us. The possibility of challenges being experienced in the implementation should not deter us from making some of these forward-looking recommendations. We do hope that we'll continue to gradually build on. We know that we may not be in the state in which other countries are at the moment, particularly with the issue of virtual meetings and so on. But we have started. We can only get better. So our recommendations are forward-looking. We hope that this will continue to improve on what we have at the moment. Training, as emphasized by Professor Mamadou, is also quite apt in the sense that without training, it will be difficult. I do recall that when we started the use of online apps to have meetings, it was initially very challenging for everybody, but we have quickly caught on to it, and we believe that once we start, the various stakeholders will begin to organize training for it. I know that the NBA can do that for lawyers, and the NJI can do that for the judiciary, and indeed the institute itself is very well placed to be able to offer some of these trainings as well. So yes, the opportunities for training are there, and I think we can take advantage of what we have. So Okon has advised on recommendation also to be post-COVID. In some of our recommendations, we were talking about beyond COVID. That is, for instance, when we were talking about virtual hearing, we were saying that it should continue post-COVID era because of the advantages it has for access to justice and, of course, of timeliness. So we do understand that some of these recommendations will survive this period that we are looking at, and we go ahead and do so even in post-COVID era. The call for appointment of adjunct judges is very apt. I think it's not just for the purpose of this COVID-19, but will also help deal with the issues of backlog that we have, we are experiencing in our courts. Other jurisdictions have made use of adjunct judges to help deal with their justice delivery system and challenges. And I think we have gotten to the point where that should also be explored. So I think it's a good recommendation that we need to look at. The DG has talked about justice policy and what is expected going forward, and I believe that he has covered grounds on that. Now, interestingly, Professor Abiola Sani talked about the link between virtual hearing and reduction of corruption. He sees the possibility of that also reducing corruption in the system, but he has also cautioned that we should put in place also other mechanisms to ensure that a new wave of corruption does not also start. I think it's also very important. All we can say as members of the committee is that having harvested these views, we'll go back and look at our report and see where there are gaps and be able to incorporate some of these recommendations in the report and put in such a way that we can take cognizance of all the views that have been shared around the table this afternoon. Thank you, DG.
All right, thank you, Professor Peter KSAN, Chairman of the committee. Like I said in the beginning, that this is an interim report from NIALS, and now actually erudite professors and other colleagues that actually, helped them prepare this report for presentation will surely accommodate some of these interventions. And then probably 2 weeks from today, we hope to get actually, an improved version of the report, taking into consideration some of the pieces of advice given to us. I would like to simply, round up on one point, and that is the concern raised by Dr. Bello Fadile on the issue of cybersecurity during criminal trials. I think we are not short of relevant provisions in our Cyber Crimes Act 2015 and in our National Cybersecurity Policy, and the implementation framework or the institutional mechanism to really actually implement this policy and also ensure enforcement of these provisions. EFCC is on ground in this respect. Office of National Security Advisor as a technical committee in this context. Some regulatory agencies have both direct and indirect responsibilities, to check some of these infractions of the cyber crimes and also ensure implementation of cyber security policy. That is National Communications Commission, and then NITDA, National Information Technology Development Agency, and also the Cyber Security, Committee for the implementation of the policy itself. I mean, then you have the entire law enforcement agencies. I think what we need is probably, an institutional, mechanism that is refocused and re-energized to understand the context of COVID-19 and its relationship with criminal trials, using, digital technology or during virtual hearings, and also the threat or the risk of actually cybersecurity, in that respect. So I think we will actually address those concerns and see whether we can engage one or two stakeholders in the area of cybersecurity, and then get their actually commitment to the implementation of the available legal and policy instruments to address these concerns raised. I would like to thank all of you, and I'd like to ask Professor Peter Akpe if he has any member that wants to give us a vote of minutes so that we can actually close this session. Thank you very much.
Did you just one information?
Yes.
Did you?
Yes.
There's a department in the Office of National Security Advisor that handles cyber security, and you can get the expert there to join in whatever the judiciary wants to do. We work together to enact the Cyber Security Act. It's still there, and very good. Thank you.
Yeah, thank you. All right, Professor Peter, any to give us some time.
Yes, thank you, DG. It's my pleasure to invite Dr. Azad Habila to say the vote of thanks on behalf of the committee, sir. I said it's my pleasure to invite Dr. Azad Habila to say the vote of thanks on behalf of the committee, sir.
Yes, if he's around, he has 30 seconds.
Thank you very much, sir, DG. We want to, first of all, on behalf of the committee, thank the DG of the Institute for the confidence reposed in the committee to be saddled with this responsibility. Want to thank you, sir, for the opportunity you've given us and all the support that the committee has received from you and the entire office towards discharging its responsibility. We want to thank the entire staff of the Institute, those who sent in their memoranda within the Institute and those from outside. We want to say a big thank you. We want to thank all attendees of this virtual meeting for sparing time to join in this meeting and to make useful contributions, especially those who tune in from outside of this country. It shows a sign of commitment from them to contribute their own quota in developing our nation. I want to thank you all for this hour that we have spent together. It is our prayer that the recommendations made by the committee will go a long way in improving the justice sector in our country and the country at large. Thank you very much, and God bless.
All right, thank you, Dr. Habila, for the vote of thanks. And I would like to call it a day. We will schedule actually another session for you next week. So bye-bye for now. Thank you.